thank you very much for joining what is the second in the series of 4 webinars marking Cornerstone's Information Law Week. I just have 3 things to say at the outset. So firstly, I think a few people have asked that this event does have closed captioning. I think you can use the link in the chat function, or there's a function on the bar at the bottom of your screen. If you have any issues with this, please just pop a question into chat and someone will hopefully be able to assist. The second thing is that there will be a recording and it will be available on our website shortly after the event. And then finally, I just want to apologise, although I'm not sure if I need to apologise for this very cosy environment that we've set up here, deviating from our usual practice of appearing on different screens. We've had a bit of a technical issue and therefore sitting quite close together, which is fine because we like each other, but not fine because we have a very big height difference. So it's taking some manoeuvring to make sure we're both on the screen. Right, so with that all in mind, we're going to kick off this morning with our webinar on do's and don'ts of data sharing. Now, in our experience and in the age of GDPR, the idea of data sharing seems to fill data practitioners with a sense of absolute dread across both the public and private sectors. In fact, there are common misconceptions or common reactions really when you're faced with data sharing that contribute to this panic. And people often instinctively believe that sharing personal data is no longer allowed under the GDPR or what is now the UK GDPR or the 2018 Data Protection Act. People also often think that actually there's nothing to be gained but trouble when you data share because things can only go wrong, that you can only share if you have individual consent, or that there is no way that you could possibly share in a one-off emergency situation. But what we are here to tell you this morning is that these are all misconceptions, and that first and foremost, there is no need to panic when faced with the prospect of data sharing. Not only does the legislation allow data sharing, but it has in fact been explicitly recognised by the ICO, which is the Information Commissioner's Office, that data sharing can be extremely beneficial, whether that is in terms of providing more efficient services, making people's lives easier, or indeed in terms of economic benefits. During the pandemic, for example, we have seen how data sharing between organisations in the public, private and voluntary sectors has been used to manage local and national responses. It's been used to support those who are vulnerable, so for example, through the shielding programme. And in essence, really, if done lawfully and properly, data sharing can open up all sorts of opportunities. So our aim today then is to provide an overview as to how your organisation can confidently data share and really what to do in terms of best practices and also what to avoid in terms of common pitfalls. Before getting into the details, what we just want to highlight at the start is that when we talk about data sharing today, what we're really focusing on is sharing personal data with third-party controllers. So we're not talking about the personal data that you share and will regularly share with a data processor. That's a totally different context and there are different rules governing that relationship. Nor are we concerned with international data transfers, which is frankly quite complicated and beyond the scope of this webinar. So coming back to what we will be looking at, I will kick off with the key principles. John will then cover how data sharing can and should work in practice, and we will then have some time at the end for your questions. But there is a Q&A function, so if you have questions as we go along, just feel free to pop them on, and John and I will do our best to try and answer them as we go along. Right, so starting with the key principles then. I think what's really important to remember is that data sharing is just one or just another form of processing of personal data. So therefore, and as an absolute minimum, you need to, don't know what I've done there. You need to ensure that you are following the data protection principles. The principles that apply to general data processing are those set out on the slide, and most of you, I'm sure, would be familiar with these, but just to go through them. The first is that personal data must be processed lawfully, fairly, and in a transparent manner. The second, that personal data should be collected for specified, explicit, and legitimate purposes, and that it should not be further processed in a manner that is incompatible with those purposes. The third is that Personal data must be adequate, it must be relevant, and it must be limited to what is necessary in relation to the purpose for which it was processed. The fourth is that personal data must be accurate and, where necessary, kept up to date. And that really there should be every reasonable step must be taken to erase or rectify inaccurate data without delay, having regard to the purpose for which that data is being processed. The next is that data must not be stored for longer than what is necessary, bearing in mind the purpose for which you're processing. And the sixth is that data must be processed in a manner that ensures appropriate security. That means using appropriate technical or organizational measures. And then finally is the accountability principle, which is that controllers should be responsible for, and more importantly, be able to demonstrate compliance with all the principles that I've just been through. At the end of that slide, I've obviously just added the third country transfers, which we won't be covering, but I just flagged that because if that's an area in which you're working, then of course you need to think about the additional rules that apply in that context. Just to flag here as well that there are, of course, slight differences when it comes to data processing for law enforcement processing. For today's webinar, we're just going to focus on the general processing rules. But again, I'm just pushing that up there so that if you are working in the different contexts, you need to be looking at the Data Protection Act and look at the slight differences there. Now, all of these principles are, of course, relevant when it comes to data sharing, but I think in our experience, there are some that take on a particular importance. And so those are the ones that I want to go through in a bit more detail. The first of these is the first part of the first principle, which is lawfulness. Now, there's actually two aspects to lawfulness when it comes to data sharing. The first thing you need to ask yourself, and particularly this is relevant to public bodies, you need to ask yourself if you have the legal power to share the data. And the second thing you need to ask yourself is whether you have a legal basis embedded within the GDPR. If we start with legal power then, for public authorities, firstly, this may include a variety of things. So for example, you might have a statutory obligation to share data. You might have a statutory power that enables you to do so. But do remember, particularly for local authorities, the law is often silent on the specific issue of data sharing, but that doesn't mean you don't have any legal power and you can't do so. But rather you will often be able to find an implied power. So, powers that are reasonably incidental to those which are expressly permitted, which means that in practice you do actually have that implied power to share data. In terms of the private sector then, it's not the same, you don't have the same burden of sort of establishing what your legal power is, but you may just want to consider whether there are any industry-specific regulations that dictate what you can and can't do. And then the final thing that I think everyone needs to think about, whether you're in the public or private sector really, is, are there any prohibitions outside of data protection law? So you might, for example, have copyright restrictions, you might owe a duty of confidence, there might just be some other prohibition on sharing information. So you just need to go through that sort of checklist in your mind before you can proceed. And then once you're satisfied that there is a legal power and no non-data protection legal barrier to sharing, you can then turn to the GDPR framework and consider whether there's a legal basis. Now, all processing of personal data and therefore all data sharing must satisfy at least one legal basis, and these are set out in Article 6 of the GDPR. Again, these are on the slide, and I won't go through each one, but I'll just flag that for public sector organisations, at least, the relevant legal basis is likely to be the fifth one on that list. Although finding it very hard to count this morning for some reason. But yes, so you're probably going to rely on the fact that it will be necessary for you to share that data for the performance of a task in the public interest. So that's the public interest task basis. For that legal basis, and actually for all of them that talk about necessary for, just remember that the test is necessary. So it must directly relate to what you're trying to do, and it must be proportionate to that objective as well. It's a high threshold to meet, so you just need to be satisfied that everything that you're doing is basically proportionate. And then for public interest task in particular, also just remember that you can't be generic about this. So, just because you're a public body, you can't just say, right, I'm a public body, so I'm going to rely on public interest task and move on. You need to be a bit more conscious and specific about what you're actually relying on or what you're using. As I said, this might be an express statutory power, it might be an implied power. You might want to consider whether you're empowered to do so under the Digital Economy Act. In fact, on the Digital Economy Act, there is specific and detailed ICO guidance on this. So again, if you're within a public authority and you're sharing with other public authorities, that might be something that you should be considering. Where the public interest task doesn't apply, or particularly for private sector organisations, you will need to consider where else, what other legal basis on that list you can really meet. So you might have to obtain specific informed consent, or you might have to be satisfied that the data sharing is necessary to comply with the legal obligations. There's just a few final things that I want to say about legal bases. So first, remember that if you're dealing with special category data, not only do you need to satisfy one of the Article 6 bases, which we just had on the previous slide, but you also need to additionally comply with the condition in Article 9. There's a whole list, so I would refer you to it, but it includes bases such as explicit consent, whether it's necessary for reasons of substantial public interest, whether it's necessary for health reasons, or necessary for legal claims. Special category personal data, most of you will be aware, is a closed list. And again, I would urge you to look at that list before you're about to share data. But it includes personal data such as that which reveals racial or ethnic origin, political opinions, health, sexual life, or sexual orientation. And then the final point on lawfulness is criminal convictions or information concerning criminal offences. Now, again, you need an additional basis for sharing this information in particular, and that additional basis is in Article 10 of the GDPR. In effect, what you must be able to show is that that sharing of that particular data is carried out under official authority, or that it meets a condition in parts 1, 2, or 3 of the first schedule to the 2018 Data Protection Act. Now, obviously, it's beyond the scope of this webinar to go into specific details of all of these things, but as I say, I'm just highlighting this here in case that issue crops up in your practice. Right, so then moving on to the second half of the first data protection principle, which is fairness and transparency. This is dealing with fairness first. There is an overriding imperative that people should be treated fairly when it comes to data processing. And really, when you think about fairness, what you should be focusing on is, whether or what really the expectations of the individuals might be. And there's no legal jest when it comes to fairness, but I think it's quite important sometimes to just have sort of like a reality or a common sense check, where you just sort of take a step back and think about whether if this was your personal data, how you would want it to be treated, or what you would expect someone to do with that personal data. And I think sometimes it's helpful to have that common sense check, because if you think about it and if you instinctively feel a little uncomfortable about it, that may be the kind of situation in which you need to think a bit harder about whether you're meeting all the other data protection principles and or whether there might be an unfairness issue. And then also linked to fairness is this idea that pervades a lot of data protection law, which is you need to be reasonable and to be proportionate in everything that you're doing. Because if you're acting in a way that's disproportionate, it's just unlikely to be fair. Right, and then finally on this is transparency. So here, the transparency obligation is obviously linked very much to the sets of obligations you have in the GDPR to provide information, certain information to individuals. These are, in Article 12, 13, 14 of the GDPR. And so there's a series of things you just need to ask yourself to be confident that you're sharing in compliance with the transparency obligations. So, think about your privacy notice, think about whether you have informed individuals about how you might share their data. Think about whether the way in which you're informing people, particularly bearing in mind who your audience is, have you done this in an accessible manner and in a manner that's easy to understand and follow? And then if you are a recipient of information via data sharing, think about whether you've complied with Article 14, which is where you collect personal data but not directly from the data subject. So again, once you go through these steps, one of the things that you'll need to look at quite carefully is your privacy notice to make sure that you have been transparent in line with what the requirements are. Then moving on to the second data protection principle, that's purpose limitation. Again, a lot of this is quite common sense in a way, but there are a series of questions that you can ask yourself to just be satisfied that you're not acting in breach of the purpose limitation principle. So firstly, if you're about to disclose information that falls within the original specified purpose for which you've collected the information, then that is going to be compatible with the purpose limitation because you're not processing it for any other incompatible purpose. But if when you consider what you're actually doing, you think that the disclosure involves an additional or a different purpose, then you perhaps need to think about it a bit more carefully. Remember that the test is about not further processing for an incompatible purpose. So just because something raises an additional or different purpose, I don't think that automatically means it's incompatible, but it is a grayer area, so you need to think a bit more carefully about whether that could be seen really as an incompatible purpose. And then when you are going through this in terms of a checklist, you should be mindful of what the third-party data controller is thinking about as well. What's their purpose for processing? Because just you might be satisfied in your mind that what you're doing is absolutely fine, but actually sometimes if you think about what the data for the third-party data controller's purposes or motivation is, that might give you some cause for concern. So just always be mindful of what they are about to do with the data. And then finally, just come back to the point again about your privacy policy. Make sure that it's updated in line with any sort of additional or different purpose that you might be processing data for. Right, jumping then to another data protection principle, which is security. There's two kind of themes here. One is internal security, and this is when you're thinking about your own organization or public body. You are, of course, required to have appropriate organizational and technical measures in place when you share data, and so you continue to be bound by this principle. So this means that you will need to think about, in particular, the technical arrangements that you have in place to share data. You need to ask yourself whether there are any risks involved with sharing the data, which might lead to, say, unauthorized access or accidental loss or damage. Remember that the focus in the GDPR is on appropriate measures. So whatever security measures you have in place, you must be guided by the nature, the scope, the content, and the context and the purpose of why you're sharing, and ensure that everything that you put in place is appropriate to those aims. Then once the data is shared, it's not entirely the case that you can just sit back and forget about security. While the third-party data controller is, of course, bound by the GDPR too, you are still under duty and should really take reasonable steps to ensure that the data that you share will continue to be protected with adequate security by the recipient organization. Now, there are a number of ways to achieve this. So, for example, you might have a set of agreed security standards in a data sharing agreement, and how you might go about this in practice is something that John will cover. You might also want to think about, sort of in advance about what IT compatibility issues you might have, whether you want to invest in joint technology. The key point, I think, to remember is that you can't simply wash your hands of the issue once you've shared the data. And that's particularly the case where you have sort of long-standing or ongoing data sharing arrangements. So then moving away from the data protection principles, the last thing that I want to cover in terms of the framework before I hand over to John is the issue of exemptions. Now, under the GDPR, the Secretary of State is enabled to introduce exemptions to the data protection obligations and individual rights in a number of areas. And these are all set out in the 2018 Act. There are a number of different exemptions. I mean, this is just a very small sample. and all the exemptions tend to reflect activities that are considered to be in the public interest. As an overarching point, I think it's important to stress that each exemption has to be considered on a case-by-case basis, because the exemptions they only permit departures from the obligations and rights to the minimum extent necessary. So you can't have you can't adopt sort of a blanket policy approach when it comes to these exemptions. There are just two exemptions that I want to touch on in particular, because we often come across these when it comes to data sharing. The first one is the crime and taxation. Now, the crime and taxation exemption only comes into play if you are processing personal data for one of three purposes. One is if you're doing so for the prevention or detection of crime. Second is if it's for the apprehension or prosecution of offenders. And then third, if it's for the assessment or collection of a tax or duty or an imposition of a similar nature. Now, if you're satisfied that personal data is being processed for one of those three purposes, then the effect of the exemption is that certain so-called listed GDPR provisions do not apply to the extent that applying those provisions would prejudice the three purposes that are set out on the slide. And just to unpack a bit further, the listed GDPR provisions they're in the schedules to the Act, but they involve or they include a range of obligations and rights. So, for example, they include the fair processing, the Article 13 and Article 14 that deal with fair processing information that needs to be provided to individuals where personal data are collected directly from the data subject. It also applies in relation to the subject access rights that are in Article 15. It applies to the rights in relation to rectification, erasure, restriction of processing. Quite importantly, it also applies to the general principles in Article 5 that we went through, but only insofar as they correspond to the rights and obligations that are in the listed GDPR provisions. And then, in particular, it applies to the first and second data protection principle. So with the second data protection principle, that's the purpose limitation that we just went through. And with the first principle, you'll hopefully recall that was lawfulness, fairness, and transparency. So the listed GDPR provision doesn't extend to lawfulness, but it does include the fairness and transparency. So I know that's a lot to unpack there, but that's something that you'll need to go through carefully if you're dealing really with this exemption, or you want to seek to rely on this exemption. And as I say, there's a lot of obligations that are effectively disapplied by these exemptions. But remember always to approach this on a case-by-case basis. And then the second one that we come across all the time when we're advising, is particularly public sector clients, but also often in the private sector, is the exemption dealing with law and legal proceedings. So this includes so this will come into play where you're disclosing personal data either first to the public via under enactment. Second, you're disclosing it because you're required to by law or by court order, and the court order in particular we see a lot. And then the third is where you're disclosing data because it is necessary for legal proceedings. And when you think about legal proceedings, it is quite broad. So it includes where that might be necessary for the purpose of obtaining legal advice. It also includes where it would be necessary for the purpose of establishing, exercising, or defending your legal rights. Again, the effect of the exemption is that where you're disclosing personal data pursuant to those three things, those three purposes or scenarios, then the listed GDPR provisions again do not apply to the extent that the application of those GDPR provisions would prevent you from doing one of these three things. As I mentioned, this is something that crops up time and time again, particularly in care proceedings or proceedings involving children. So we've had, I think both John and I have advised on different cases, but time and time again, really, that the court will often make an order requiring reports to be produced. And there's always a concern among clients about flouting the data protection rules or disclosing information, particularly sensitive information about children. But really, provided that you're mindful of the exemptions and you're properly applying them, there is, of course, a proper basis for sharing that information, and it should not be something that gives you undue cause for concern. So with that overview of the legislation, I'm going to hand over to John.
Thank you, Ruchi. I might get you to actually hold on to the mouse just to check the questions and answers while we're working through, if that's okay. I'm going to look now in practical terms about when you are sharing data with third-party data controllers, what does it look like in practice? So if we go on to the first slide, let's just consider what does it look like. So the forms of data sharing that you might see are things like a reciprocal exchange of data between two different organizations. You might also see providing data to a third party in a very straightforward way. We often see several organizations who pool information together. So you might have social services, police, a school, all pooling information together about something that's going on. It also takes the form of exceptional one-off disclosures. So emergency situations, unexpected situations, we see disclosure. And then you might have some regular disclosure, flow of information pursuant to a data sharing agreement. So that's the kind of forms of data sharing we're talking about. We go on to the next slide. So who are we sharing with? Well, bearing in mind what we've just said, the types of third-party data controllers that we're sharing with will generally be things like another company within a group. We often find our clients are sharing with financial institutions like banks and insurers. Professional advisors, of course, is a big one that comes up all the time. So that would be your lawyers, your accountants, your auditors. Police and Inland Revenue is a regular organization that people share with. And of course, we're going to look at an example later this afternoon on that. Government agencies, so the Child Maintenance Service might be an example. Local authorities, of course, are regularly asking us to share information with them, particularly the social services teams. And there might be partner businesses engaged in joint marketing where you're sharing. So then thinking about who we are sharing with, what sort of scenarios typically arise when we share personal data? Well, here's just an example of the types of scenarios. So you could have a group of retailers exchanging information about employees who were dismissed for stealing. You might have a primary school who's passing details about a child showing signs of harm to the police or social services. Or you could have, for example, the police who are passing information about the victim of a crime to a counselling charity. Or you could have a GP who's sending information about a patient to hospital. So with all that in mind, if we go to the next slide, let's imagine that you're sitting at your desk this morning, it's 11:30 a.m., you're checking Instagram and Twitter, you're half engaged in a data sharing webinar while drinking your morning latte, and suddenly into your inbox comes an email from a third-party data controller asking you to share some personal data with them. What do you do? Well, the first step has to be to turn to the ICO data sharing code of practice. Now, the code is really, really important because it's published pursuant to Section 121 of the Data Protection Act 2018. And as a result, if you're engaged with data sharing and you don't comply with the guidance in the code, you'll probably find it more difficult to demonstrate that your data sharing is fair, lawful and accountable, and that it complies more generally with the UK data protection legislation. So that's your Bible of data sharing. Now, it runs to some 89 pages, but it has a really helpful quick reference guide on pages 7 to 9 so that organizations can easily identify the information they need. And it really deals with a wide variety of matters, specific areas, things like data sharing and children, sharing in the context of law enforcement proceedings, and sharing personal data in databases and lists as well. So you'll have regard to the code, and in light of the code, what you will also have regard to are what Ruchi just mentioned about the relevant principles that you should always bear in mind in terms of Article 5 UK GDPR. You will then be asking yourself, do any exemptions apply? It's often the case, as I mentioned, that the police, for example, will be relying on the crime and detection and prevention of crime exemption. And if that's the case, as Ruchi mentioned, the obligation is on the police to make out that there would be prejudice to their investigation if the listed GDPR provisions were complied with. So don't be afraid to make sure that from an accountability perspective, that you have a documented written trail that the police are actually explaining what would the prejudice be in relying on when they're seeking to rely on this exemption. You're then going to ask yourself, do you need to do a DPIA? So at one point in the code recommends that when deciding to share personal data, as a first step, organizations should carry out a data protection impact assessment. Now, they're not legally obligated to do that. There's only certain circumstances where you have to do that under Article 35 GDPR, but the code does recommend you do it. And I think there will probably be a lot of people who think, wow, that sounds like a lot of work for a very simple sharing exercise. But the reality is that a lot of DPIAs are actually quite discreet and short. They often aren't more than a page long. And as the code says itself, in preparing a DPIA, it's actually very helpful because it allows you to assess any risks in sharing the data. It promotes public trust in data sharing, and it helps you to understand whether you actually are permitted by law to share the personal data and what steps you need to take to mitigate any sharing risks. So do think about doing DPIAs if that email comes in asking you to share. You're going to also ask yourself, do we have a data sharing agreement in place? Now the code has emphasized that data sharing agreements are really good practice, especially in order to demonstrate compliance with the accountability principle under the UK GDPR. And that's because the agreement helps all the parties to be very clear about what their roles are. It sets out the purpose of the data sharing, and it covers what happens to the data at each stage of the sharing process. Now, unfortunately, the code doesn't actually have a data sharing agreement template. That would have been really helpful if there was some sort of template, but it does set out in quite a lot of detail the types of issues that an agreement should address, which I'll talk about later on. Finally, then, you're going to ask yourself, what policies and procedures you have, because you should have data sharing policies and procedures, and we'll look at what they should look like shortly. And then when you've gone through all of that, the key thing that you're going to look at is the data sharing checklist. And if we go on to the next slide, Ruchi, there is an ICO data sharing checklist, which is really, really useful if we see the kind of things it's asking us to consider, to turn your mind to. There's a heading, is the sharing justified? And then a series of questions underneath that. Have you considered doing a DPIA? So again, asking you to turn your mind to that. There's a checklist section then about being clear about what you are sharing, how you are sharing, and compliance with the principles. For example, making sure you have a lawful basis for the sharing. And finally, then, it encourages you to document your decision. And of course, again, that goes back to what Ruchi was talking about the umbrella principle, really, the accountability principle in Article 5.2 of the UK GDPR, which is this accountability principle, which is having the sort of regulatory trail of documentation, such that if and when things go wrong, there's a personal data breach, there's some other individual right that's said to be infringed, you're in a position where you can actually say to the ICO, well, look, we went through all of these processes, they are all documented, here is the evidence for it. So that's the checklist. I want to come back then to the data sharing agreement. So if we go to the next slide, please, Ruchi. So if you have a data sharing agreement in place, and what should that data sharing agreement look like? So the data sharing agreement will, first of all, you need to be thinking about what are the key benefits in having that data sharing agreement. It's helping you to set out the clear roles, it's setting out the purposes of the data sharing, it's covering what happens at each stage of the data being shared, and it's effectively setting standards by which you're going to abide while you are sharing data. Now, as I say, there's no template in the ICO code, and an agreement can take really a variety of forms depending on the scale and the complexity of the data sharing that's going on. But really, when you want to have data sharing agreements where you're doing regular sharing with a different organization. So regular sharing you know, often is the case between partner organizations such as social services and the police. I often see data sharing agreements between central government or departments and local authorities, particularly between the Ministry for Housing and Local Government, or the Levelling Up Ministry, as I think it's now called, and local authorities. They're the types of situations where you want to have a data sharing agreement. What should the data sharing agreement include? Well, it will want to have the parties, of course, the purpose of the agreement. So what are the specific aims of the agreement? Why is the data being shared to achieve those aims? And the benefits you hope to bring to individuals or to society more widely. Which organizations are involved in the data sharing? Again, there might be outside of the agreement, there might be an understanding that the data is actually going to others. And so they should be mentioned in the agreement too. What items are we going to share? So what exactly is the personal data that is being shared? That should be set out in the agreement. The agreement should, it doesn't need to be heavy on law, and often people put the law, the legal aspects in an appendix, but it should set out the lawful basis for the processing that you're doing. And there should be provision for individual rights as well. And what I mean by that is, how does someone make an access request? You can direct people to one controller or the other in terms of access requests or other individual rights, albeit an individual can still make an access request to either data controller. It should have a section on information governance. And what I mean really by that is information about making sure the data sharing is accurate. So how are you keeping records up to date? Having common rules maybe about deletion or retention of personal data. Having common technical and security arrangements between the two of you in terms of protection of the data. How is the data flowing between the two of you? Is it being done securely in line with the integrity and confidentiality principle? And finally, you might want to have a review clause in the data sharing agreement, because of course, this is an area of law which is relatively new, at least in terms of the GDPR. And so, and we know, of course, and I'll talk about this shortly, there's a data reform bill coming down the tracks. So again, data sharing agreements could usefully have some sort of review clause that should trigger sort of updates to the agreement in the event of certain circumstances. So if we go on then, Ruchi, to the next slide. So you've considered the data sharing agreement. You will also be considering, when you're sharing, is what are your policies and procedures in relation to data sharing? And the ICO in the code says very clearly there's a number of ways you can meet the ICO's expectations. First of all, you need to show that you have some review process to assess the sharing, the potential sharing. So that could be through a DPIA, could be through some sort of similar exercise where you're actually analyzing the legal benefits and the risks to do with the sharing. Absolutely have to document your decisions. You, of course, should have clear policies and procedures and guidance about data sharing. And what we really mean by that is, you know, that staff who are involved in data sharing actually have done trainings like this, more specific detailed training on the particular types of data sharing they're doing, and that they understand the seriousness of the sharing of data that's going on. They're aware of their responsibilities and they know how to carry out those responsibilities effectively, and they know who to escalate matters to if things go wrong or if they have particular queries about the data sharing in question. So all of those things should be documented in policies, but the key thing, of course, with policies is we always remind clients is that it's all well and good having the policies, but if you haven't actually implemented the policies in terms of training, in terms of just general promotion of the policies in the workplace and making sure they're implemented, then they're not good for anything. So really having the policies and the procedures in place is really important to meet the regulators' expectations, particularly if things go wrong. So that's, if we go on to the next slide, Ruchi, just then look at one or two examples. So the first example, we have, take for example, a housing association occasionally receives requests from utility companies, debt collectors, councils for information about current and former tenants. that's the type of situation where, at least in my experience, a lot of housing associations, they don't have a data sharing agreement with those bodies because they're not really engaged in data sharing on a very regular basis. So instead, they're going to be considering the requests on a case-by-case basis. And the things they might be thinking about are things like, what have tenants been told? So is there information in the housing association's privacy notice about the potential third parties that tenant data might be sent to? Is there anything in the tenancy agreement? Sometimes I see clauses in the tenancy agreement about sharing personal data with other relevant bodies. And who in the association is dealing with the request? Is it someone who actually has some knowledge of and understanding of data protection rules and regulations? That's really, really important. And then if we go on to the next practical example, the typical one that we see, as I mentioned already, is the police who are asking for asking social services really to address details of one of their clients, or sorry, to get address details from one of the social services clients in order to contact them urgently in connection with a criminal investigation. And of course, what the police are going to be relying on here is the crime and prevention exemption. So you have to interrogate that question of whether there is going to be prejudice. If you need to make sure, I've seen it before and it's not appropriate, you need to make sure this is all in writing rather than over the phone in terms of the request. There is actually a data sharing request template, which is at the back of the ICO code of conduct or data sharing code. So I'd encourage you, if you don't have a template in your organization, to at least use that template and invite people who are making requests to fill in a template like that. And you will also be asking yourself, what does your privacy notice say? And again, the vast majority of local authorities' privacy notices that I review and I've seen tend to have information about how they will be sharing with organizations such as the police, such as, of course, HMRC, other bodies. It's important to always remember, I think there's a common misconception amongst data subjects that, well, we haven't given our consent for that sharing, so that, you can't share on that basis. And of course, as Ruchi's talked about, there are of course other lawful bases for why you're processing the personal data. And so you don't need consent. And you really, to be honest, shouldn't be asking for consent in those types of situations either. Finally, then, there's just one or two other useful tools I want to draw to your attention. So the first of those tools is the advice on information sharing from the government. So it's really specific to information sharing for practitioners providing safeguarding services to children, young people, parents, and carers. It was published in 2018, so it is post GDPR, and it's a really, really useful piece of advice, particularly as it sets out what the government see as the 7 golden rules of sharing information, which really apply to all types of information sharing. They mention things like GDPR is not a barrier to sharing. It's a framework to enable sharing. You shouldn't see it as a blockage. It emphasizes being open and honest with individuals about sharing, seeking advice from other practitioners as well. If you're in any doubt about the sharing, again, never be afraid to ask or instruct a barrister. Also, where possible, sharing information with consent if it's appropriate, but also making sure that you consider safety, well-being, proportionality, necessity, accuracy, security, all the things that Ruchi mentioned really that were mixed up in those principles. Then you also have the ICO Data Sharing Information Hub. That's really useful, and that's where you'll find the code, you'll find those templates, and you'll find other information more specific to particular sectors as well. Finally, then, before we just turn to questions, I want to mention, and I've seen it come up in the Q&A as well, the Data Reform Bill. So some people will have noted that in the Queen's speech just last week, the government announced its intention to introduce a data reform bill. Really quite sort of strident language saying that it needs to take advantage of the benefits of Brexit to create a world-class data rights regime that reduces burdens on businesses, boosts the economy, helps scientists to innovate, and improves the lives of people in the UK. So there are some interesting aspects to the proposal. Obviously, it's not all fleshed out yet, but for example, the ICO is going to be sort of modernized. given powers to take stronger actions, although the ICO actually already does have a lot of powers. And of course, the other aspect is that the proposed bill describes the current regime as highly complex and prescriptive, which they say imposes excessive administrative burdens on businesses. And so the proposal there is also to make some changes to alleviate the burdens on businesses. Now, we don't know the extent of that. We know that, of course, there's an adequacy agreement in place between the UK and the EU, and that the proposal is that adequacy agreement, which will expire in 2025, the UK is going to seek to extend that. So there'll have to be a delicate balancing act really with the data reform bill, because if there's too much of a departure from the EU GDPR, the risk that adequacy agreement becomes undermined potentially. So there'll have to be care taken there. So if we turn to questions, there's one question that I just saw that I'll just take, which was on joint controllers. Someone wrote in just at the beginning about joint controllers, saying what are the obligations on joint controllers. Really look at Articles 47 and 26 of the UK GDPR. You have to have suitable arrangements between the joint controllers when you're sharing data between them. And what that really means is that, well, it doesn't have to be a contract, it doesn't have to be in writing. Ideally, you will put that in writing, and you'll set out the respective roles of the parties, the relationships of the joint controllers vis-a-vis the data subjects, and making sure that's, the essence of, is the phrase used in the GDPR, the essence of the arrangements are made aware to data subjects, and data subjects sort of know who to contact about different exercise of different individual rights. So really, joint controllers, you've got a similar issue to sharing with third-party data controllers, but you have to have that sort of arrangement in place. So, Ruchi, what are we doing with questions?
Right, Andy has a question, which is, I would really like to see a template one-page DPIA. Do you have one?
I will try and dig one out, Andy. I've definitely seen one, because of course the DPIA, for those who aren't really familiar with them, only really has 5 or 6 questions, the screening stage, then going all the way to the final stage where you're analysing how you've mitigated the privacy risks. So I'll take note of your name and I'll try and dig one out.
I'm just reading through Claire's question, Claire Jarvis, about fireys and about the scope of public authorities' common law powers. I think there's a lot in that question, really, but I think stepping back, I mean, the common law powers are only applicable to sort of ministers, so a lot of day-to-day public bodies that will be involved, certainly the ones that where we see problems crop up and issues crop up, they're all creatures of statute, including local government and other public bodies. So their powers are very much derived from statute, and there's no common law powers. So unless you've got a statutory power or implied power, really you can't you can't rely. There's no common law powers really to fall back on. And certainly the work that I've done for central government departments, I'm trying to wrap my brain, but that's not something that we've come across. It's I would feel quite uncomfortable really if I was advising a central government department to rely on a common law power, because really there's just so much other legislation that's involved that unless you should really be able to find sort of an implied statutory power to do something, even as a central government department. Just scrolling through the other questions then.
So Julie Gerard asks, with the proposed reform to data protection, i.e. the data reform bill, is there likely to be a need for more data sharing agreements in the future, particularly when sharing special categories of personal data and parties are joint controllers? Are the Caldecott principles likely to be reviewed also given the proposed reforms? There's no indication, at least when I read the Queen's speech, that the Caldecott principles were going to be reformed as part of that review. And to be honest, I mean, we all saw the detail in the Queen's speech. I think over 30 bills are proposed. So whether even the data reform bill will see the light of day remains a question. But if it does come forward, I don't necessarily think that we will need to see more data sharing agreements, because as I say, really data sharing agreements are specifically for those regular sharing. And to be honest, the whole tenor of the data reform bill is the idea of cutting back red tape and sort of less administrative processes. So I would be surprised if there was sort of a mandatory data sharing agreement for things like special category data, as you mentioned.
The next question we have is from Noara about the scope for legal proceedings. The scope for the legal proceeding exemption, and whether it could apply where the data, where you're basically asked to share, but you're not a party to that claim, so you're effectively assisting a third-party data controller. Yeah, I think in principle that's fine. As you say, there'll be risks for the data. If you're the data controller who's not involved in the litigation and you're sharing that information, you need to think through some of the risks. But if you can, just thinking back to what the scope or how it's drafted, at least in the schedule to the DPA, it's broad enough to cover basically, otherwise necessary for the purpose of sort of defending legal rights. And if you have hold of that information and you're sufficiently comfortable that it meets a sort of necessary, test of, meets that sort of high threshold and meets a test of proportionality, I think that's something that would fall within that exemption.
Then Greg Dwyer asks, when a data sharing agreement is sent across for signing and you disagree with what is included, such as retention, are you still liable even though you are both data controllers? Well, I would say, first of all, if you disagree with something in the data sharing agreement, don't sign it. But retention is a tricky one, because there will be some data controllers who have different reasons for retaining data, because remember, there's no prescriptive limits about retention in the data protection legislation. So as long as one data controller is able to justify why it's necessary to retain the data for a certain period, it may be the case that you, Greg, your organization takes a different view about the necessity, but I don't think necessarily when it comes to liability that kind of transfers across in that way. Lauren Barney, is it sufficient to have a memorandum of understanding between public bodies to data share? Absolutely. We regularly see memorandums of understanding. They're usually a bit less detailed, but they set out sort of the framework, and yeah, that's something we see all the time.
There's quite a few about circulating the one-page DPIA. So
no pressure on me.
So if we find that, we'll just send that.
Yeah.
We'll send that more broadly. So I'm just trying to.
Someone said, will there be any reforms to the LED, so the law enforcement directive? I'm not aware of any reforms coming down the track in that respect.
Sorry, I might have dismissed that prematurely. Then, in relation to the legal advice proceedings exemption, presumably proceedings that might subsequently happen will suffice. Yes, there's another question about this. I mean, so you need to think about what stage you're at, but someone asked about whether it would apply to pre-action stage, and absolutely it would. And then similarly, even if you're not in formal pre-action correspondence, but you think, well, I mean, it would depend on the circumstances. I wouldn't want to give any sort of definitive answer, but it would depend on what stage you're at and what indication you have that something is going to be litigated. And if so, then yeah, you need to take a judgment call at that stage. But by the time you're at pre-action stage, if you've got any sort of non-formal pre-action correspondence, that I think would be sufficient. And then so I'm just trying to scroll through. Simon, we mainly share information with the police. This is usually urgent, and I've never known them to complete a data request document. Should we refuse even in an emergency?
No, so there are situations where in an emergency you are permitted to share personal data, because of course you've got the sort of the vital interest exemption there, which is often the case that's relied on in an emergency. But you should sort of, I sometimes see a lot of people who are reluctant to sort of push back against the police because it's the police, but they, they're obligated to comply with the data protection legislation just as much as anybody else. And so unless it's an emergency, you should really be documenting, because it's from your own perspective as an organization to protect you from a regulatory perspective, and indeed from a civil action perspective from an individual, that you should be making sure you're sharing in compliance with the Act. And then finally, I'm not sure what that question, if that is a question, someone has said there's established case law on CPR versus SARS. Great. Thank
you. Well, I think we've gone through all the questions.
Yeah. Is there anything in the chat? Do you want to just see if there's anything? Yeah, David says 1 page deep here.
Yeah.
Don't worry.
You don't need to type that again.
Maybe not this afternoon, but I'll find it for you.
Oh, there's lots in the chat, but let me try and
So we've just 2 minutes left. So thank you everybody for joining. Really, really hope that you benefited from today. There's nothing in the chat that's standing out to me as needing to be addressed. Someone mentioning police don't really tend to send anything either. But yeah, so thank you all for joining. It's 11:58, so I think maybe we'll stop there.
Yes.
Hopefully this whole format of us sitting beside each other wasn't too odd or distracting. It was my fault in terms of my laptop wasn't working this morning. So, but thank you all for joining. We had over 200 participants. So I hope you enjoy the rest of your day.
Yes, thanks very much. Bye.